5 seconds to go. Start. She strangled the child when her mother-in-law PW1 was out of the house. Stop. According to PW6 Jamal Muhammad, the appellant was not in Periambalpur at the relevant point of time, and she came to Periambalpur with him on 21st June 2007 in the late afternoon after receiving information about demise of the child, and thereafter, she was arrested. Stop. Some of the other prosecution witnesses were also given the same suggestions in the cross-examination. Stop. These aspects lead to the plea of alibi, as has been referred to and relied upon by the learned counsel for the appellant. Stop. Para. The trial court and the high court have examined the evidence on record and have rejected this plea of alibi with reference to the significant features of the case, that there is no corroborative evidence on record, to the assertion made by PW6 Jamal Muhammad, that on 20th June 2007, he took his daughter back to his village Kolakudi. Stop. The accused appellant did not adduce any evidence to prove that she was not present in Periambalpur, at the time and place of incident. Stop. Apart from the fact that PW1, PW2 and PW3 consistently maintained their versions that the appellant was available at the time and place of incident, two independent witnesses, PW4, landlord of PW1 and PW5, neighbor of PW1, testified that they saw the appellant sitting with or near the body of the deceased child immediately after, and at the place of, the incident. Stop. Although there appears to be no reason to discard the testimonies of PW2 and PW3, but even if, for the sake of argument, their testimonies are left aside for being directly related witnesses who might not be favorably disposed towards the appellant, there appears no reason to disbelieve and discard the testimonies of PW4 and PW5. Stop. Nothing even remotely has been shown as to why PW4 and PW5 would be interested in testifying about the presence of appellant around the time, and at the place of incident. Stop. Para. Apart from the foregoing, fact of the matter also remains that the appellant was arrested on 21st June 2007, that is, the very day of the incident, albeit 9 hours after the incident, at the bus stand. Stop. However, when the theory propounded by PW6 Jamal Muhammad that the appellant had travelled to Kolakudi with him on 20th June 2007 and then travelled back to Periambalpur on 21st June 2007 is discarded, all other facts taken together lead to the logical conclusion that the plea of alibi is required to be rejected. Stop. Para. Another major factor highlighted and elaborated by the learned counsel for the appellant relates to certain discrepancies appearing in the versions of PW1 Basira, as stated in the complaint made to the police compared with her assertions before the court. Stop. No doubt, there had been some such discrepancies in the matter which, at the first blush, give rise to certain doubts as to whether the testimony of PW1 could be believed or not. Stop. However, a close look at the record makes it clear that the discrepancies, said to be of contradictions in the versions given by PW1 Bashira, could only be considered to be normal and natural, or being the result of her want of proper comprehension. Stop.